It was just not one of those things. I mean, you were assaulting, and then let's see, you stated some terrible vulgarities. Were you aware of that? So, you want me to say them out loud to the general public, or so that we all know what kind of person you really are?
No, sir. Not a bad person at all, sir.
Oh, I'm sorry. It's not what we think we are. It's how we act.
Right.
Isn't that right?
Yes, sir.
How did you act here? Are you Mr. Antoine?
Yes.
Come on up. Greg. All right, once again, which one is which? 1607 was pleading.
1607 is the dismissal. 1606 is the plea.
25 CR 1606 is called your tender Antoine with Ms. Manaldi, your attorney and the state's attorney does. The defendant waived formal reading of the indictment and arraignment to proceed in summary.
Yes, Judge.
In summary, the states that on or about October 13th, 2025 in Jefferson County, Texas, you committed the second-degree felony assault on a peace officer.
We did both.
Oh, okay. Okay, in 25 CR 1606 again, you were Mr. Antoine, your attorney and the state's attorney, and again, in summary, on or about October 13th, 2026, 2025 in Jefferson County, Texas, the state you committed the second-degree felony of assault on a peace officer by kicking the complainant in the stomach with your feet, and you knew the victim was a peace officer lawfully discharging an official duty. You understand which was arresting you? Do you understand what you're charged with here?
Yes. This is my
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes, sir.
An agreement's been reached with you would be pleading guilty, so 2 years in prison, and then the other case, 1607 here, would be dismissed. Is that your understanding of the agreement?
Yes, sir.
If I follow this.
Quick context here: assault on a peace officer is a second-degree felony in Texas, meaning it legally could have carried up to 20 years. The plea deal on the table brings that all the way down to 2, with a second case getting dismissed entirely. That's a pretty significant gap between what he was exposed to and what he's actually agreeing to.
You have no right of appeal of your case, do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. This states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with, the indictments and the read to you. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
You understand what you did wrong here?
Yes, sir.
What?
Assaulting a police officer.
Sir?
Assaulting a police officer.
Well, I mean, what do you think about that?
That
I'm sorry.
I apologize about it. I
Were you in your right mind?
wait.
Huh?
No, sir.
Why not?
Can't explain this moment. It's just one of those things.
It was just not one of those things. I mean, you were assaulting, and then let's see. You stated some terrible vulgarities. Were you aware of that?
So,
You want me to say them out loud to the general public, or so that we all know what kind of person you really are?
no, sir. Not a bad person at all, sir.
Oh, I'm sorry. It's not what we think we are. It's how we act.
Right.
Isn't that right?
Yes, sir.
How did you act here?
This exchange is the moment people are going to remember from this one. The judge doesn't just accept the plea and move on. He makes the defendant actually sit with what he did and said during the arrest without repeating the specific words out loud for the record. It's a pointed way of holding someone accountable for their conduct, not just the legal charge on paper.
Poorly. Correct?
Right.
Yeah. You are mentally competent to enter your guilty plea, the court finds. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. As you have given up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses, I now find you guilty beyond a reasonable doubt of this assault on a peace officer, a second-degree felony offense. I'm following this agreement. Hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. You understand what has happened today?
Yes, sir.
Anything else?
No, Judge.
That is all.
Thanks, Judge.
I'm talking with Ms. Moore on one of hers, trying to figure out if that one's gonna be dismissed or not, and then what the direction of the others will be.
Okay.
If we could have 2 weeks on that.
You got 2 weeks. All right. And ma'am, your name, please.
Crystal Bass.
Your Crystal Bass. Okay, you've got 2 cases, Ms. Bass, in 25 CR 1809 and 1810. Assault on hospital personnel and hospital property. Each of these cases on or about, well, one wasn't alleging on or about November 8th, 2025, that event. And the other is on or about October 14th, 2025. And then the indictment, God bless you, goes on to allege that in 2019, you were convicted out of Hardin County District Court for attempted aggravated assault. So these 2 charges on assault on hospital personnel are third-degree felonies. If all of this was found true in these indictments, your punishment range is a second-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you have, according to the indictment, been previously convicted of a felony which eliminates any probation. And look at this. And she had earlier been evaluated by Dr. Ed Griffon for the issue of competency to stand trial, and Dr. Griffon, in a letter dated June 26th of this year, a week or so ago, deemed the defendant to be competent to stand trial. In this evaluation, which the court is going to mark as court's exhibit 1, but it's going trying to in each of these cases. Every single one of those is evaluated. I don't have enough room to write. Use 2 exhibit stickers. Okay, this is court's exhibit 1 for each of these cases. It's part of the record and sealed for the purposes of related issues that may come up during the trial. What are we doing?
Judge, I just wanted to go over her options with her. She has a current offer from Tommy Coleman, the new prosecutor in her case. That's only good for today. He's offering a plea for 2 years, running concurrently on each case. After today, that offer will go up to 5 years. As you explained to her, you do have 2 pending third-degree felonies. You understand that, right?
Yeah, speak out so she.
And then with that prior that you have on the record, you understand that you wouldn't be eligible for any kind of probation out of trial.
This is a real pressure point in plea negotiations that people don't always see. The offer on the table is 2 years, but it's only good today. Wait past this hearing and it jumps to 5. Combine that with the fact she's already got a prior felony, which knocks probation off the table entirely and pushes the punishment range up to 2 to 20 years at trial, and you can see exactly why the attorney is walking her through this so carefully before she decides.
Okay. And with that prior that you have on your record as well, that would also enhance you to a higher punishment range. So instead of your punishment range at trial being the third-degree felony range of 2 to 10, it would enhance to 2 to 20. You understand that? You understand that you have a current offer on the table for 2 years TDC, and then you have 140 days credit.
Yes, ma'am.
Okay. And are you wanting to accept that offer, or do you want to set your case for trial?
I'll accept the offer.
Okay.
Is this a plea in each case?
Yes.
To run concurrently? Right. That's your understanding?
Is that what you want to do? You can set your case for trial.
Write it up.
I just need to make sure that you understand all of your options.
Write it up. That's good today.
Okay.
Thank you. Thank you. We'll get to this here.
And she takes the deal 2 years, running together across both cases with credit for the 140 days she's already served. That's the second case in this video where the pressure of a same-day deadline shapes the whole decision. If you're finding these real courtroom breakdowns useful, subscribe so you catch the next one. And let us know in the comments which case in this video hit hardest for you.
Should you say Burkett as a bond hearing? Yeah, we're gonna get to that.
Sure, that's fine.
Moves up stuff.
Here.
We'll get to that later though. Bridget.
She's a plea judge.
No. Okay, that looks like it is. All right, Bridget Wedlow. You're all ready?
Yes, Judge.
Bridget Wedlow, it's on page 4. Kendall, thank you. You're doing a good job, by the way. We lost our other bailiff for,
Thank you.
who had been there for 100 years.
They didn't lose him. He retired.
He retired.
They're some great friends.
So you don't feel like he's a loss to us, huh?
We will feel
I see.
but
Okay, I understand what you're trying to say.
for him in his retirement.
Well, he
She's jealous.
kind of said if it weren't for you, he'd have stayed. That's what he inferred.
We worked together for 15 years. He put a
I know.
long time ago, those to me.
He called that a living hell. By the way, is the way he described that.
Biggest statue. Congratulations, week one.
Congratulations. She's like top lady in court coordinator in this profession. She's got a special degree, and also her final that she had to prepare is being published on bringing live coverage, YouTube, the case court TV to people. And because of the efforts Lacey did, she got a special honorary award for that. She graduated first in her class. Yeah, smart lady.
She's a.
Yeah, just raise your right hand.
And I think
Pictures of the class.
we're gonna miss Dennis. Nice guy. He was with me for the whole time.
Really?
20 years. Yeah. I guess he just got tired of me, really.
Yeah, it's not you, Lacey. You knew it was his time.
When we were in high school, he went to Beaumont French. I've supported his ropes. I ran track he threw the shot and the discus, the state records for those two events. He was a famous guy, because he was big. He was the size he is now when he was in high school, and he was strong, man. Yeah, nicest guy. Yeah, we're gonna miss him.